Chapter 1, Part 2. Okay, so there's an interaction between the law and ethics. Ethics is the principles governing what constitutes right or wrong behavior. As we said before, the law does not always clearly follow what is right and wrong. Sometimes it's simply a compromise. But in business today, we have to be aware of not only the laws, but we also have to be aware of what has become a very important topic, business ethics. So business decision makers need to consider not just whether a decision is legal, but whether it's ethical. And we will have an entire chapter on business ethics. Okay, so where does the American law come from? We have what we call the primary sources of law, the first sources of law. And those sources are constitutions, statutes, regulations, and common law. Unfortunately, it's not up there, but common law, or what we call case law, is another primary source of law. By primary in this situation, we mean the law itself, what has to be followed. Secondary sources are sources that summarize and clarify the primary sources of law. Those would be things like law reviews, legal encyclopedias, what we call treatises, which are scholarly writings about the law. These secondary sources are extremely important for a number of reasons. They give us guidance in interpreting and applying the primary sources of law. For lawyers and also for others, secondary sources are helpful in helping us to locate primary sources. So as I always tell lawyers, young lawyers or law students or paralegals, if you're starting to research a legal problem that you're not familiar with that area of law, it's best to start with a secondary source like a treatise, because that treatise or encyclopedia of law will give you a background of the area of law, sort of like your textbook does, and it will lead you to other sources of law. So for example, in your textbook, periodically it will cite or give reference to cases that set forth those principles of law. Those will often be in your textbook in footnotes, and that allows you to go from a secondary source to the actual case or case law, or common law as we call it, by looking it up based upon that footnote. So the primary law is the law itself. As we said, it's constitution, statutes, regulations, and case law. Case law is also referred to sometimes as common law. It also includes treaties and executive orders. Okay, we don't deal that much in everyday life with treaties. Treaties are agreements between countries, and in particular it would be something that we, the United States, entered into with a foreign government. However, in the current modern times, we're leading more and more into needing to know about treaties, because we're doing more and more international business and international transactions that might involve treaties. And we'll talk a little bit about that when we talk about contracts, because nowadays we're not only entering into contracts with people in the United States, but through the internet and other things we're entering into contracts with people in foreign countries, and that sometimes means that we have to be aware of the laws that govern those, and sometimes those laws have been enacted in treaties. Talked about secondary law, and then we also, for legal research purposes, talk about finding tools and citators. Finding tools are things that help us to find the law, and citators are used to check the history of law. Citators are extremely important because anytime you use a law, a primary source of law like a statute or a case, you want to make sure that it's still current. You don't want to cite a case or a statute that has been overturned or has been supplanted by a new statute by a legislative body. So we have to have a method of doing that, and we have what are called citators, and we'll get into that a little bit more in another lesson. Okay, so constitutional law is the highest level of law, meaning it trumps any other kind of law. We have a federal constitution, United States Constitution, and all states have their own constitutions. Excuse me, Georgia has its constitution. In Georgia, we have to follow both the Georgia Constitution and the U.S. Constitution. Excuse me, and if the Georgia Constitution conflicts with the U.S. Constitution, then the U.S. Constitution prevails. We also have statutory law. We have statutory law that is both federal and state statutory law. Federal statutory law is passed by Congress in Washington, D.C., and for Georgia, our state statutory law is passed by the Georgia General Assembly or the Georgia Legislature here in Georgia. Okay. You can see from this that we have a system we'll talk about a little bit later, and that's a system called federalism, where the federal government and the state governments share power. The Constitution of the United States gives certain powers to the federal government, and anything that's not given to the federal government is reserved to the states. And the states are free to do whatever they choose to do with those powers that are reserved to them, so long as they do not violate any of the provisions of the U.S. Constitution. Okay, so there's a little chart concept of these different areas of primary law. Let me talk just 1 second before we shut off and go to the next video about common law. Common law developed in England, where courts would decide cases and they would pronounce legal principles. Okay? And so, for example, if somebody sold somebody else a mule and the mule turned out to be blind and the purchaser sued the seller, the court might come up with a rule, which is what they actually did in those days, called caveat emptor, buyer beware. And so the court would rule in favor of the seller and say, it's the buyer's problem, the buyer should have inspected more carefully. That rule then would have had to have been applied in all subsequent cases. That's why it was called common law. So if the court had a case at a later date with the same facts, the court couldn't deviate. However, if the facts were a little bit different, then the court could deviate. So for example, if the buyer said, I asked the seller if the mule was capable of seeing well at his age, and the seller said yes, then the court might deviate and say that there was a warranty given, and that warranty was breached when it was found out that the mule could not see. And so they could come up with a new principle of law, what we call precedent, and it would say that even though caveat emptor, buyer beware, applies, if the seller makes a promise or a warranty, then the seller has to live up to that warranty. So that's how the law developed in England. When we became a country, we adopted that common law, those principles of law that the courts had developed in England, and made it our body of law. And over the years it became known more as case law because it came out of cases than it did as common law.